Hi, everyone, and welcome back to Becoming Counsel. Today, we are covering an essay that will touch on the Fourth Amendment standing, criminal attempt, and the abandonment defense. So let's jump into the fact pattern. Let's say Marcus, age 19, and his friend Devin, age 16, decide to break into a pharmacy one night. They plan to steal prescription drugs from the back storage room. Now they park down the street and they walk towards the pharmacy's back entrance, each wearing gloves. Marcus also carried a black backpack containing bolt cutters and a crowbar. Now the two stood near the back door for close to a minute. Marcus tried the door handle and found it to be locked, and then he began examining the padlock on the storage gate while glancing repeatedly over his shoulder. Devin starts to get nervous. He starts breathing heavily and says, "I can't do this. What if we get caught?" He turns and runs back to the car. Now, Marcus lingers for about another few seconds. He looks at the lock, sighs, and then follows Devin to the car. Now, they didn't know that a silent alarm had already been triggered by motion sensors. And as they drove off, Marcus basically says to Devin, "Man, that was too close," and sped away. 3 days go by, and then the police show up at Devin's home, where he lives only with his mother. The officers told Devin and his mother that Devin was a suspect in an attempted burglary and asked to search the house. Now, Devin's mom asked if they had a warrant. They said not yet, but we can get one. So she decides to let them in anyway. While searching the house, they get to Devin's room, and in his room, they find that black backpack. Apparently, after they drove off, Marcus had given the backpack to Devin and had asked him to get rid of it. But he hadn't, it was in his closet. Now, these police officers, without asking Devin's mother whether she knew who owned the bag, and without obtaining a warrant, as we had mentioned, they open up the bag, they find the bolt cutters, the crowbar, and a burner phone. On the burner phone, they found a text message from Marcus to another person that was sent a week prior, essentially laying out his plan to break into the pharmacy with Devin's help. Now, Marcus was charged with attempted burglary. His attorney has moved to suppress the backpack and its content, arguing that the search violated Marcus's Fourth Amendment rights. Now, the trial court has denied that motion, and the issue was preserved for appeal. At trial, Devin testified for the prosecution consistent with the above information. The prosecution introduced the backpack, the tools, and the phone into evidence over the defense's objections. Marcus presented no contrary evidence. The trial court denied Marcus's motion for judgment of acquittal and denied his request for jury instruction on the defense of abandonment. The jury eventually convicted him on attempted burglary. So the questions here is, did the court error in one of the following? Number one, did it error in denying Marcus the motion to suppress the backpack and its contents? Number two, did it error in denying Marcus's motion for judgment of acquittal? Or number three, did it error in failing to instruct the jury on the defense of abandonment? So let's break this down using the IRAC method. So let's start with that first question, which is, did the trial court error in denying Marcus's motion to suppress the backpack and its contents? So let's start with the issue. So the issue is whether Marcus had standing to challenge the search of Devin's home and the backpack found there. The Fourth Amendment protects against unreasonable searches and seizures, but a defendant may only challenge a search if he or she has standing, meaning she had personally held a reasonable, legitimate expectation of privacy in the place that was searched or in the item that was seized. A person generally has that expectation in their own home or when they're an overnight guest in someone else's home. That expectation is surrendered once a person voluntarily hands an item over to someone else and essentially gives up control over it. So let's analyze that a little more. The backpack wasn't found on Marcus's person, nor was it found at his home. It was found in Devin's bedroom. Nothing in the facts suggests Marcus was an overnight guest there, so he had no independent expectation of privacy in Devin's home. More importantly, Marcus voluntarily handed the backpack to Devin and told him to get rid of it. By handing it off and disclaiming it, Marcus gave up whatever expectation of privacy he had in the bag and its contents. Without a personal privacy interest in either the home or the bag, Marcus has no standing to challenge the search at all. The court never even needs to reach where the search itself was reasonable because he doesn't have standing to even challenge it. In conclusion, for this first issue, the trial court did not err in denying the motion to suppress. So let's look at issue 2, the motion for the judgment of acquittal. The issue here is whether the prosecution presented sufficient evidence for a reasonable jury to find Marcus guilty of attempted burglary beyond a reasonable doubt. Now, the rule here is a motion for judgment of acquittal should be denied if the evidence, viewed in the light most favorable to the prosecution, would allow a reasonable jury to find every element proven beyond a reasonable doubt. The attempt requires an attempt of burglary requires specific intent to commit the underlying crime, and number 2, it requires conduct that goes beyond mere preparation. So, like under the model penal code, a substantial step is strongly collaborative of criminal intent. Some jurisdictions instead use dangerous proximity test. Now let's apply that here. Intent is well supported here. There's a text message from a week prior on this phone that was recovered that laid out Marcus's plan. There's Devin testimony corroborating that the two coordinated the break-in together. There was substantial steps. Not only did they drive there, but they both were wearing gloves. Marcus had a backpack full of tools. They came up to the door. They tried to open up the door, and they even started looking at potentially how to use some of those tools to open up the padlock. That conduct is well beyond just mere preparation. A reasonable jury could easily find it is strongly tied to intent and the intent to burglarize the pharmacy. Therefore, in conclusion, for this item, the trial court did not err in denying the motion for judgment of acquittal. So let's look at issue number 3, the jury instruction on abandonment. So the issue is whether Marcus was entitled to that jury instruction on the defense of abandonment. Now the rule here is that in many jurisdictions, they recognize abandonment as a defense to attempt, but only where the abandonment is voluntary and complete, not motivated by fear of apprehension, an increased risk of detection, or a decision to merely postpone the crime for a better opportunity. So let's apply that here. The facts here point squarely towards fear-motivated abandonment, not a genuine change of heart. Devin's own statement was essentially a statement of fear. Essentially, he said, "What if we got caught?" Now, Marcus lingered for a few extra seconds, still examining the lock before following him. And once in the car, he commented, "That was way too close." It reflects relief at avoiding detection, not remorse or voluntary decision to give up the plan. Now, that same fact pattern, courts have repeatedly held disqualifies a defendant from abandonment defenses. Stopping essentially because you got scared is not voluntary abandonment of a potential crime. You need to have that kind of mental decision of like, I don't want to do this anymore. And do it because you don't want to commit the crime rather than fear. So in conclusion, for this third item, the trial court did not err in refusing to instruct the jury on abandonment. So with that, we've addressed the 3 questions tied to this fact pattern. And so hopefully it helps you understand standing, that substantial step towards doing something, in voluntary abandonment. This is essentially how law school professors like to test criminal law and procedure together. I hope you found this helpful. Thank you.